Has everyone got a copy of the jury instructions? Very well. Just keep in mind that what I said before about reading applies now. Don't read ahead, okay? If you're out in the audience and you have a cell phone or any other electronic device, make sure that you have it turned off. All right, we'll begin page 1. Members of the jury, you have heard all the evidence and the arguments of counsel. It is now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are 2 possible punishments. Number 1, life imprisonment without the possibility of parole, or 2, death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No fact other than proven aggravating factors may be considered in support of a death sentence. Count 1, aggravating circumstances. Number 1, the aggravating factors alleged by the state are as follows as to count 1. Number 1, Mr. Toledo was previously convicted of another capital felony and or a felony involving the use or threat of violence to another person. The crimes of felony, armed burglary of a dwelling, felony robbery with a firearm, felony kidnapping while armed with a deadly weapon, felony second-degree murder as it relates to the others, and capital felony first-degree murder as it relates to Thalia Otto are all felonies involving the use or threat of violence to another person. 2, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. 3, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The word cold means that the murder was a product of calm and cool reflection. The word calculate means having a careful plan or prearranged design to commit a murder. A killing is quote-unquote premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. Number 4, Michael Elijah Otto was a person less than 12 years of age. Number 5, Michael Elijah Otto was particularly vulnerable because Mr. Toledo stood in a position of familial or custodial authority over the decedent, Michael Elijah Otto. Count 2, aggravating circumstances. The aggravating factors alleged by the state are as follows as to count 2. Number 1, Mr. Toledo was previously convicted of another capital felony and or felony involving the use or threat of violence to another person. The crimes of felony, armed burglary of a dwelling, felony robbery with a firearm, felony kidnapping while armed with a deadly weapon, felony second-degree murder as it relates to Yesenia Suarez, capital felony first-degree murder as it relates to Michael Elijah Otto, are all felonies involving the use or threat of violence to another person. 2, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. 3, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The word cold means the murder was a product of calm and cool reflection. The word calculated means having a careful plan or prearranged design to commit the murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. Number 4, Aaliyah Otto was a person less than 12 years of age. Number 5, Aaliyah Otto was particularly vulnerable because Toledo stood in a position of familial or custodial authority over the decedent, Aaliyah Otto. As explained before the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond every reasonable doubt, and you must not consider it in providing your verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravator factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility or parole. At such a point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors or factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. Mitigating circumstances, which are applicable to both counts 1 and 2 of the indictment. Unlike aggravating factors, the finding of a mitigating circumstance does not have to be unanimous. Each juror makes an individual decision as to each mitigating circumstance. If you do unanimously find that the existence of at least one aggravating factor and that the aggravating factors are sufficient to impose a sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance can be anything in the life of the defendant which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. Among the mitigating circumstances you may consider are, number 1, the capacity of Mr. Toledo to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. And also, number 2, the existence of any other factors in Mr. Toledo's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty, including but not limited to the following. A, on the day and night of the crime, the defendant's mental capacity to conform his behavior to the constraints of the law was substantially impaired by mental illness. B, Mr. Toledo spent time as an inpatient in the child psychiatric ward of Mount Sinai Hospital in New York for 7 months as a 9-year-old. C, Mr. Toledo was diagnosed with behavioral issues as a child. He attended Walter J. Damrosch School in New York. D, Mr. Toledo suffered the sudden death of his mother, Ada La Santa, to a heart attack in 2002. E, Mr. Toledo is a loving family member, brother, cousin, and uncle. F, Mr. Toledo has attempted to better his life by obtaining his GED and enrolling in technical college. G, Mr. Toledo has a long history of head injuries and concussions. H, Mr. Toledo has a history of being admitted to the hospital for multiple physical injuries. I, Mr. Toledo has many disabilities and attended special education classes the entire time he was in school. J, the defendant was attending trade school, Barber College, to better his life. K, Mr. Toledo has a history of varied employment, including construction, masonry, the fast food industry, and collections. L, the defendant has and maintains a relationship with his 16-year-old daughter. M, Mr. Toledo was generous with his time and helped his friends, including helping Robin Roberts when she ran out of gas. N, Mr. Toledo has demonstrated grief and remorse. O, on October 26, 2013, Mr. Toledo tried to kill himself. P, Mr. Toledo had an abnormal psychiatric history as a child. Q, the defendant's father, C. Carlos Alberto Toledo, died of ALS at the age of 39. R, Mr. Toledo's family lived in public housing in the Bronx in New York. S, Mr. Toledo has the capacity to form loving relationships even while incarcerated. T, Mr. Toledo was shot in the head and face and still has pellets in his head. U, Mr. Toledo attended church and is religious. V, Mr. Toledo demonstrated good behavior during the trial. W, Mr. Toledo had a good relationship with his parents. X, Mr. Toledo has been emotionally unstable since he was a young child. Y, according to his educational records, Mr. Toledo had a poor school record and was required to attend special education classes. Z, Mr. Toledo dropped out of school in the 9th grade but earned his GED while incarcerated. Double A, Mr. Toledo was a caregiver for his dying father. Double B, the defendant has a history of cutting himself. Double C, Mr. Toledo's mother died while he was incarcerated and he never got to grieve properly. Double D, Mr. Toledo was involved in a car accident in the year 2000, which rendered him unconscious and in the hospital for 4 days. Double E, Mr. Toledo has a very rare IQ score, leaving him in the bottom 2% of the general population. Double F, Mr. Toledo has a defective frontal lobe, which affects his impulse control. Double G, Mr. Toledo has a defective temporal lobe, which produces seizures. Double H, Mr. Toledo has had a grand mal seizure since the age of, he should read 3 years old. The number 9 is incorrect on the instructions. Double I, Mr. Toledo has early symptoms of amyotrophic lateral sclerosis, also known as ALS or Lou Gehrig's disease. Double J, Mr. Toledo has bipolar disorder. Double K, Mr. Toledo has a seizure disorder. It is the defendant's burden to prove that mitigating circumstances exist. As explained before these proceedings, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror individually persuaded as to the existence of a mitigating circumstance must consider it in this case. Further, any juror individually may consider a mitigating circumstance found by another juror, even if he or she did not find that factor to be mitigating. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. You will now engage in a weighing process. Pursuant to Florida law, the aggravating factor of victim is less than 12 years of age, and victim was particularly vulnerable because Mr. Toledo stood in a position of familial or custodial authority over the decedent, are considered to merge because they are considered to be a single aspect of the offense. If you unanimously determine that the aggravating factors of victim is less than 12 years of age and victim was particularly vulnerable because Mr. Toledo stood in a position of familiar or custodial authority, have both been proven beyond a reasonable doubt, your findings should indicate that both aggravating factors exist, but you must consider them only as one aggravating factor during the weighing process that I am about to explain to you. You must weigh all of the following. A, whether the aggravating factors found to exist are sufficient to justify the death penalty. B, whether the aggravating factors outweigh any mitigating circumstances found to exist. And C, based on all of the consideration pursuant to these instructions, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total of number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or value by different viewers. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance, regardless of the results of each juror's individual weighing process. Even if you find that the sufficient aggravating factors, sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I have said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. And your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous. And your decision to impose a sentence of death must be unanimous. After you weigh your weighing process, your verdict in this case must be either 1, a unanimous sentence of death, or 2, a unanimous sentence of life in prison without the possibility of parole, or 3, a non-unanimous sentence of life in prison without the possibility of parole. You will be provided a form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. I'd like to go over the verdict form at this time. There's only one form will be sent for each count. There should be identical in every aspect. I'll just go over count 1. In the verdict here, it has the style of the case, which we explained to you that once before. And then I want to read the whole form to you. It's going to take some time. It's a lengthy form, 23 pages. It says, we the jury finds as follows as to Luis Toledo in this case. And then it says Section A, aggravating factors as to count 1. Again, both verdicts are going to be identical with the exception of the count 1 relates to count 1 and the other one relates to count 2. Anytime you see things in brackets or parentheses, those things are instructions for you to follow. And here it says, please answer all 5 interrogatories first. And then it says, number 1, we the jury unanimously find that the state has established beyond a reasonable doubt the existence of the aggravator that shows Mr. Toledo was previously convicted of another capital felony and or a felony involving the use or threat of violence to another person. Then there's some parentheses that check only 1, a blank for yes and a blank for no. Number 2, we the jury unanimously find that the state has established beyond a reasonable doubt the existence of the aggravated factor that the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Again, check only 1, a blank for yes and a blank for no. Number 3, we the jury unanimously find that the state has established beyond a reasonable doubt the existence of the aggravator that the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Check only 1, blank for yes, blank for no. Number 4, we the jury unanimously find that the state has established beyond a reasonable doubt the existence of the aggravator that Michael Elijah Otto was a person less than 12 years of age. Blank for yes and a blank for no. Number 5, we, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravator that Michael Elijah Otto was particularly vulnerable because Mr. Toledo stood in a position of familiar or custodial authority. Again, check only one, a blank for yes and a blank for no. Then an instruction for you says, if you answered yes to at least one of the aggravating factors listed, then please proceed to section B. And then below that it says, if you answered no to every aggravating factor listed, then stop now and do not proceed to section B. Mr. Toledo is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole. And section B, it states as follows: sufficiency of the aggravating factors as to count 1. The question here says, reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, section A, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. And then there's a blank for yes and a blank for no, and then below that another instruction. If you answered yes to section B, then please proceed to section C. If you answered no to section B, then do not proceed to section C. Mr. Toledo will be sentenced to life in prison without the possibility of parole. And then section C, statutory mitigating circumstances as to count 1. Now, a reminder to you that these do not have to be established by unanimous vote. In number 1, we, the jury, find that the capacity of Mr. Toledo to appreciate the criminality of his conduct or to conform to his conduct to the requirements of law was substantially impaired was established by the greater weight of the evidence. A blank for yes and a blank for no. And then I'll read this instruction only one time, otherwise it'll take too long. Below that is this instruction says, if you answered yes above, please provide a jury vote as to the existence of the capacity of Mr. Toledo to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law was substantially impaired. And then it says vote of blank for votes in favor of the mitigating circumstance, and the other ones to blank votes against it. So you disclose the actual breakdown of the vote. And that instruction is after every mitigating circumstance. And then 2A, we, the jury, find that on the date and night of the crime, the defendant's mental capacity to conform his behavior to the constraints of the law was substantially impaired by mental illness, was established by the greater weight of the evidence. A blank for yes and a blank for no, and then below that, if the answer is yes, a breakdown of the vote. 2B, we, the jury, find that Mr. Toledo spent time as an inpatient in the child psychiatric ward of Mount Sinai in New York for 7 months as it should read as a 3-year-old child, and I'm going to make that correction myself from the verdict form, was established by the weight of the evidence. Again, a blank for yes, blank for no, and again, if your answer is yes, you have to disclose the votes. 2C, we, the jury, find that Mr. Toledo was behavioral issues as a child, and that he attended Walter J. Damrosch School in New York, was established by the greater weight of the evidence. Blank for yes, and blank for no, and if the answer is yes, you need to establish a breakdown of the vote. 2D, we, the jury, find that Mr. Toledo suffered the sudden death of his mother, Ada LaSanta, to a heart attack in 2002, was established by the greater weight of the evidence. Again, a blank for yes and blank for no. 2E, we, the jury, find that Mr. Toledo is a loving family member, brother, cousin, and uncle, was established by the greater weight of the evidence. Blank for yes and a blank for no. 2F, we, the jury, find that Mr. Toledo has attempted to better his life by obtaining his GED and enrolling in technical college, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2G, we, the jury, find that Mr. Toledo has a long history of head injuries and concussions, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2H, we, the jury, find that Mr. Toledo has a history of being admitted to the hospital for multiple physical injuries, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2I, we, the jury, find that Mr. Toledo has many disabilities and attended special education classes the entire time he was in school, but was established by the greater weight of the evidence. Blank for yes and a blank for no. 2J, we the jury find that the defendant was attending trade school, Barber College, to better his life, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2K, we the jury find that Mr. Toledo has a history of varied employment, including construction, masonry, the fast food industry, and collections, was established by the greater weight of the evidence. Blank for yes and blank for no. 2L, we the jury find that Mr. Toledo has and maintains a relationship with his 16-year-old daughter, was established by the greater weight of the evidence. A blank for yes and a blank for no. We the jury find that Mr. Toledo was generous with his time and helped his friends, including helping Robin Roberts when she ran out of gas, was established by the greater weight of the evidence. A blank for yes and a blank for no. We the jury find that Mr. Toledo has demonstrated grief and remorse, was established by the greater weight of the evidence. A blank for yes and a blank for no. Counsel, please follow along in case I skip a page, okay? 2O, we the jury find that on October 26, 2013, Mr. Toledo tried to kill himself, was established by the greater weight of the evidence. A blank for yes and a blank for no. And I keep reminding you that if the answer is yes, you have to disclose the breakdown of the votes. 2P, we the jury find that Mr. Toledo had an abnormal psychiatric history as a child, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2Q, we the jury find that Mr. Toledo's father, C. Carlos Alberto Toledo, died of ALS at the age of 39, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2R, we the jury find that Mr. Toledo's family lived in public housing in the Bronx, New York, was established by the greater weight of the evidence. It's a blank for yes and a blank for no. 2S, we the jury find that Mr. Toledo has the capacity to form loving relationships even while incarcerated, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2C, we the jury find that Mr. Toledo was shot in the head and face and still has pellets in his head, was established by the greater weight of the evidence. So a blank for yes and a blank for no. 2U, we the jury find that Mr. Toledo attended church and is religious, was established by the greater weight of the evidence. There's a blank for yes and a blank for no. 2V, we the jury find that Mr. Toledo demonstrated good behavior during the trial, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2W, we the jury find that Mr. Toledo had a good relationship with his parents, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2X, we the jury find that Mr. Toledo has been emotionally unstable since he was a young child, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2Y, we the jury find that according to his educational records, Mr. Toledo had a poor school record and was required to attend special education classes, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2Z, we the jury find that Mr. Toledo dropped out of school in the 9th grade but earned his GED while incarcerated, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2AA, we the jury find that Mr. Toledo was the caregiver for his dying father, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2BB, we the jury find that Mr. Toledo has a history of cutting himself, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2CC, we the jury find that Mr. Toledo's mother died while he was incarcerated and he never got to grieve properly, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2DD, we the jury find that Mr. Toledo was involved in a car accident in the year 2000 which rendered him unconscious and in the hospital for 4 days, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2EE, we the jury find that Mr. Toledo has a very rare IQ score, leaving him in the bottom 2% of the general population, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2FF, we the jury find that Mr. Toledo has a defective frontal lobe which affects his impulse control, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2GG, we the jury find that Mr. Toledo has a defective temporal lobe which produces seizures, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2H, we, the jury, find that Mr. Toledo has had grand mal seizures since the age of 9 years old, was established by the greater weight of the evidence. I think I made a mistake. This is the one that should read 3 years old.
Yes, I recall.
So it should read 3 years old on this one. 2H. And the other one I was incorrect. That was which one?
Yes, sir, that was 2B.
2B?
2B.
Okay, 2B should stay as 9 years old. Folks, if you want to make a notation on your instruction. I'm going to correct it right now. 2B is correct as it was printed. There's 2H that needed to be amended 3 years ago.
2H.
2H, I'm sorry. 2H. Moving on to 2II. We, the jury, find that Mr. Toledo has early symptoms of amyotrophic lateral sclerosis, also known as ALS, or Lou Gehrig's disease, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2J, we, the jury, find that Mr. Toledo has bipolar disorder, was established by the greater weight of the evidence. A blank for yes and a blank for no. 2K, we, the jury, find that Mr. Toledo has a seizure disorder, was established by the greater weight of the evidence. A blank for yes and a blank for no. And remember that if the answer is yes on the mitigators, you have to disclose the vote. Then there's an instruction at the very end. There says, please proceed to section D regardless of your findings in section C. Section D, eligibility for the death penalty for count 1. We, the jury unanimously find that the aggravating factors that were proven beyond a reasonable doubt, section A, outweigh the mitigating circumstances established in section C above as to count 1. The answer is either yes, and then it tells you an instruction below that. If you answer yes to section D, then please proceed to section E. And below that, if you answer no to section D, then do not proceed. Mr. Toledo will be sentenced to life in prison without the possibility of parole. And then section E, jury verdict as to the death penalty, count 1. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, section A, that the aggravating factors are sufficient to warrant a sentence of death, section B, and the aggravating factors outweigh the mitigating circumstances, section D, we, the jury, unanimously find that Luis Toledo should be sentenced to death. And there's a blank for yes and a blank for no. And then an instruction below that. If you answered no, then fill out the vote disclosure below. Our vote to impose a sentence of life is blank for death to blank for life. If your vote to impose death is less than unanimous, the trial court shall impose a sentence of life without the possibility of parole. Then it says dated this blank day in St. Johns County, Florida, and it needs to be signed and dated by the foreperson. And like I said, count 2 verdict is identical to count 1. I'm going to go back to the jury instructions now. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that human life is at stake, and bring your best judgment to bear in reaching your verdict. When considering aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, number 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? Number 2, did the witness seem to have an accurate memory? Number 3, was the witness honest and straightforward in answering the attorney's questions? Number 4, did the witness have some interest in how the case should be decided? Number 5, did the witness's testimony agree with the other testimony and other evidence in the case? Number 6, had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Number 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. As expert witnesses are allowed to speak to one another during the course of the trial. Their testimony should not be discredited because they may have spoken to one another. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness, that you or may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant exercised a fundamental right by choosing not to be a witness in this case. He must not be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Now, these are some general rules that apply to your discussions. You must follow these rules in order to make a lawful decision. Number one, you must follow the law as it is set out in these instructions. If you fail to follow the law, your decisions will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number two, your decision must be based only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of exhibits and evidence, and these instructions. Number three, your decisions must not be based upon the fact that you feel sorry for anyone or that you are angry at anyone. Number four, remember the lawyers are not in trial. Your feelings about them should not influence your decision. Number five, your decision should not be influenced by feelings of prejudice, racial or ethnic bias, or sympathy. Your decisions must be based on the evidence and the law contained in these instructions. You have heard evidence about the impact of this murder on the family, friends, and community of Michael Elijah Otto and Talia Otto. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss of Michael Elijah Otto's and Talia Otto's death. However, you may not consider this evidence as an aggravating factor. Your decisions must be based on the aggravating factors, the mitigating circumstances, and the weighing process upon which you have been instructed. Two separate crimes were charged in the indictment with respect to Michael Elijah Otto in count 1 and Talia Otto in count 2. Therefore, a separate sentence is to be imposed for each of the crimes charged. Although in these proceedings the sentencing for both crimes have been tried together, the aggravating factors and the mitigating circumstances applicable to each of them must be considered separately, and a separate verdict returned as to each. A sentence of life in prison without the possibility of parole or death as to one count must not affect your verdict as to the other count charged. In just a few moments, you will be taken to the jury room by the bailiff. When you have reached your decisions in conformity with these instructions, the appropriate form should be signed and dated by the foreperson. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case, and you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or by any other means. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those type of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the bailiff. During this trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any exhibits, please make that request in writing. Deciding this verdict is exclusively your job. I cannot participate in your deliberations in any way. Please disregard anything that I may have said or done that makes you think that I prefer one verdict over another. If you need to communicate with me, send a note to the bailiff signed by the foreperson. If you have a question, I will talk to the attorneys before I answer it. So that could take some time. You may continue your deliberations while you wait for my answer. I will answer any question if I can in writing or orally here in open court. Just before I give the last paragraph, we know who our alternate jurors are at this time. So you'll follow the jury to the jury room, but don't go up into the deliberating room. Just remain outside there, and I will meet you there. I'll have your certificate and work excuse. Again, reminder, no electronics in the jury room. I'm not going to give you a schedule for smoke breaks. If you need a break, just let the bailiff know, and then he'll let me know. There is menus down here. If you think you're going to need a meal, let us know. Give us about an hour's notice so we can get that going. Also, if you feel that we need to stay overnight, give me as much notice as you can give me. If you have any questions, please use this form, okay? This is for our record keeping purposes. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. You may retire to deliberation.